Okay, good afternoon. Welcome to Portland State University. My name is John Mackler. I'm on the staff of the Oregon Transportation Research and Education Consortium. And we're really happy to welcome today staff from DLCD and ODOT to talk to you about amendments to the Transportation Planning Rule and the Oregon Highway Plan. We have a full afternoon planned, so after I welcome you here for a second, I'll be turning the microphone over to Matt Crall and Michael Rock for today's program. If you didn't pick up an agenda on your way in, or if you didn't, you should have. If you're watching from the web, you got the same email that got you here, got you a copy of the agenda, so you can follow along to see what's going to happen and when. Before we get started, I'd like to ask those of you who are here what sectors you represent. So who's from the public sector? Most of you. Private sector? One of you. Advocacy groups, nonprofits? One of you. Academics? One of you. All right, well, we've got any groups I missed? None of you? Okay. All right, and for all of you untold millions out there in the internets, to test our email system, when you ask questions and answers, I should apparently scroll down to get this. There I am. So later on when we take your Q&A, we're going to have you send emails to this address here, to the number right here on your screen, psuseminar@yahoo.com. So send us an email now, make the subject line what sector. So just write public sector, private sector, and we'll get 400 email in our inbox and we'll know who's watching. So send that and then we'll have a sense of who's watching out there over the web. So sit back and relax. We're going to give you a lot of information today about amendments to the Transportation Planning Rule and the Oregon Highway Plan. It's great to have, as always, these agencies, DLCD and ODOT, partnering on their work. On behalf of Portland State and OTREC, we're very glad to have the opportunity to host this training, this learning opportunity. So with that, I'll pass it off to Matt. You turned on your...
Thank you. So just an overview of what we're going to go over today. I'll do a little bit of a background information on the Transportation Planning Rule, and Mike will join me for a little bit on the Oregon Highway Plan. And then we will get into the details of the amendments to the Transportation Planning Rule, the Oregon Highway Plan. We'll take a break, give everybody a chance to get questions ready, email questions in from out there, organize that. Well, then we'll go to some question and discussion period where we'll talk about get some feedback on these things, or if there's things we didn't explain well enough, we certainly want to do that. And then we will have another section at the end where we'll get into talking about Portland metro area and some of the specific things that apply here that may not apply elsewhere. So if you have questions or discussion related to that, hold those for that part. So in terms of the background, Transportation Planning Rule, the Oregon Highway Plan, how they connect together, and the concerns that have led us to this recent round of amendments. It is important to keep in mind the Transportation Planning Rule was adopted by the Land Conservation Development Commission. Despite the word transportation in the name, it is part of the land use planning system. It implements the statewide planning goal 12. And I always like to keep in mind that the Transportation Planning Rules is a lot more than just, we're going to be talking about 060 today, but there's really a whole bunch that came before that, well, 000 through 0050, that talk about how to do proactive planning, the transportation system planning, planning in advance of a rezone or a development. But of course, we are here mostly today to talk about, and a lot of the attention focuses on TPR 060. The reason being, there is this overall imbalance in our transportation system, and this is nothing new. This has been since the very beginning when the Transportation Planning Rules were first adopted in the early 90s, that the amount of projected traffic is out there, or is likely to be out there, greatly exceeds what is likely to be built in terms of the funding and the capacity that we have to build. That was known when the Transportation Planning Rules were set up, when those first TSPs were going on. And a very conscious decision was made by LCDC at that point not to require everyone to go back to their comprehensive plans and try to fix this balance, try to force folks to re-examine the acknowledged plans, but simply to realize at that point that this imbalance exists. And thus, Section 060 was added that says, when you are doing changes, when you are doing plan amendments, when you're doing rezonings, don't make that imbalance any worse. That, if we could just sum it up, try to move closer to balance. When we talk about 060, there's a couple of key terms that we're going to end up hitting a lot. The significant effect. Would this plan amendment, zone change, or regulation change have a significant effect on the transportation system? If it would, will the transportation system meet the performance standards? Will it not meet the performance standards? It's important to remember that the performance standards themselves are not in the transportation planning rule. Those are in the local transportation system plans or in the statewide plan. Another key point is that all of this talking is measured at the plan horizon. What is the projected development? What are the projected performance? What's the projected capacity? And another phrase we'll hear from time to time, reasonable worst case. Not one of my favorites. It came out of case law. It's not in the transportation planning rule, anywhere in there. And one of the things that's tough about it is actually worst. In many cases, it's the best case. If you think about it, if you're rezoning land for economic development, the best case is that a lot of development happens there and that a lot of jobs happen and that good things happen. So the word worst is kind of a problem in there. But it's the phrase we use. Also want to talk about some background, and then Michael is going to give some overview on the highway plan.
Okay, thanks, Matt. Good afternoon, everybody. I'm Michael Rock. I'm with the Oregon Department of Transportation in the Transportation Development Division, which is our central planning section for the agency. So I work a lot with our various statewide and modal topic plans. So I just want to take a minute as part of the background introduction to talk about the Oregon Highway Plan a bit, and then I'm going to get into a lot more detail on what the amendments were a little bit later. But the Oregon Highway Plan is it's adopted by the Oregon Transportation Commission as part of the statewide transportation system plan. Essentially, it's one of the modal plans that's underneath the policy umbrella of the Oregon Transportation Plan. So it's an element for the highway system among many different actual modal and topic plans that the agency has. Much like the TPR, the Oregon Highway Plan, it's a broad, document, a broad policy document that covers a lot of different areas. It essentially establishes the policies for management and operation of the state highway system, and ODOT uses it, pretty closely in that regards. But it's broad. It contains the policies around classification of the highway system, integrating land use and transportation, establishing key aspects of the freight system on the state highways, operational improvements, ITS, all that type of thing. But often, the part of the Oregon Highway Plan that gets the most attention is Policy 1F, which is the Highway Mobility Policy. It used to be referred, before this recent round of changes, as the Highway Mobility Standards Policy. It's just one policy among many in there, but it's an important one. And one of the reasons that it gets the most attention is actually the interaction between the OHP and the Transportation Planning Rule through that policy. So what Policy 1F does is establishes essentially mobility objectives for the state highway system. And the objectives are consistent with what the other Oregon Highway Plan policies are. They talk about the importance of the freight system and whatnot, but establishes essentially the congestion thresholds for the state highway system. Well, these standards, or now what we're calling targets, are the performance standards that are referred to under the TPR section 060 that Matt just mentioned for the state highway system. So this policy is a key aspect for really all the transportation planning work that we do, whether it be at the transportation system plan level, the facility plan level, or dealing with land use amendments as in 060 of the TPR. So because of that, we knew that we had to be working closely with the LCD on this work, and so that's why we're both here. That's why we often do outreach together. That's why we had a coordinated process moving forward. So with just that quick overview, I'll turn it back over to Matt.
Okay. So that's the Transportation Planning Rule, the Oregon Highway Plan. They're both great. I mean, who can argue with the idea that we should have some policies on mobility? Who can argue with the idea that if you're going to be rezoning land, let's not try to make an existing problem any worse. We should try to get it better. What's the issue here? Well, we started hearing quite a few concerns. especially hearing more about it probably in the middle of 2010, towards the end of 2010. So as a result of these concerns, the two commissions formed a joint subcommittee because these two issues are so intertwined that there's really no way to address one without addressing the other or to work them separately. Joint subcommittee was set up to try to clarify the concerns, took a lot of testimony, heard from folks on that, figure out a scope of actions, what we should do. To do that, they met in early 2011, went through that process. This is a little bit of what they came up with in their recommendation report. Two broad themes came up in terms of the concerns. One is economic development, and a keyword, balanced. We need to balance economic development with transportation performance. Right now, we've got something, well, we were going through a recession. Technically, I guess we're out of the recession, but it still feels a lot like it. Jobs are pretty important. Economic development is pretty important. That balance probably shifts a little bit in times like this, and there was some concerns that the combination between TPR and OHP was making it hard to do economic development. The other theme, this idea of compact development, of downtowns being the active, vital heart of community, avoiding sprawl, smart growth, whatever words you phrase, that's something that's built right into the land use planning system. But if TPR and OHP are making it harder to do that, well, that's an unintended consequence. That's a problem, something we need to address. So the result of that was they recommended we did need to amend both of those. Not a big surprise by the time we'd gone through that process. And they recommended that we had to have this very coordinated joint process to work on the two of them because they are so connected. In addition to those broad recommendations, they had some specifics, and so here were 5 items that were specifically called out from that to be amended in the TPR. And likewise, a list of 5 items called out to be edited or amended in the Oregon Highway Plan, some issues to address. Now, it just so happens that at the same time that this joint subcommittee was meeting, another group was meeting in Salem to talk about these issues. The 2011 legislature. There were several bills, quite a lot went into that, some different ideas came out. At the end of all that process, what came out was Senate Bill 795 that built on that joint subcommittee recommendation and said, that's no longer a recommendation. This is now a mandate. You will go review those items, and you will get it done by the end of the year. So we set out to do that. Which brings me in the agenda to the details of the TPR amendments. We did have a process to go through there. The key point I would raise on this one is they took effect January 1. So we did meet that deadline, and they are available for use right now. There are 3 new sections and 3 changes in existing sections. And if you have, hopefully you picked up the handout. It's a 2-page summary. It's got the 3 new sections summarized on the front, and the 3 changes existing are summarized on the back. And you can also get that from our website. Anybody watching? And that's useful. And then also, hopefully folks picked up a copy of the rules themselves, because I'm going to refer to them. There's an 8-page back there. Oops, sorry, I bumped the mouse. So let's talk about the new sections and changes to the existing section. The first new section is section 9, and it's, I think, on page 7 in the rules. And you will note page 6. And it starts off, it's all underlined and bold because it's a whole new section. So all that text is marked there. One of the concerns we did hear when working through the process was that when a rezone is being proposed, if it's consistent with the comp plan, if it's consistent with all the planning that's been gone on before, and we're really just bringing things into conformance, this should not be a situation that requires a lot of extra transportation analysis to do that. And in general, we agreed with that. And in fact, in many situations, that has been the way it's been done. Maybe not as consistently. And so looked at that and said, probably a good idea to put some actual text in the TPR that clarifies that and says, this is the way it's going to be done. So I tend to classify this one as a streamlining, but in many ways it's not a huge substantive change, not really changing the policy in a major way. There was, however, quite a bit of discussion in preparing this one about this first point, consistent with the TSP. Consistent with a comprehensive plan is a pretty simple concept to say, is this zoning fit within that comprehensive plan designation? The question about, well, what prior transportation planning and how do you judge that turned out to be one that the Rules Advisory Committee spent a lot of time working through, worked through several drafts. I wrote some of those drafts, and I will admit at this point, with the benefit of hindsight, that they didn't work. And the Rules Advisory Committee was not shy about pointing out that overly detailed and kind of some prescriptive ways of looking at consistency was not going to work for all cities. So what we ended up with when the Commission adopted these last December is subsection B there, if you're looking at the rule. The local government has an acknowledged TSP, and the proposed zoning is consistent with the TSP. And not a lot of description about what that might mean. So that's something that you need to look at each TSP and see what's in there. A lot of times the way consistent ends up being interpreted is not inconsistent. If there's something that's specific in the TSP that is inconsistent with this rezoning, then you would not be able to use Section 9. Doesn't mean you can't do the rezoning. There may be other ways to work through it, but not through Section 9. An important point here is that if it qualifies under Section 9, it is declared to be not a significant effect. That's a bit of a shortcut, and it cuts out some of the analysis that would otherwise have to happen. So if it's consistent with the comp plan, consistent with the TSP, you don't have to do traffic projections. You don't have to do volume to capacity ratios. Don't have to do performance or queuing or any kind of that kind of analysis. Then there's one other key point in here, subsection C, relating to UGB expansions. When a urban growth boundary is expanded, there's a section of that rule that says you don't have to apply the detailed provisions of 060. The reason being for that, you may be looking at more than, well, you should be. You should be looking at more than one spot for this potential UGB expansion. So rather than do detailed analysis for a number of different places, many of which will end up not being included, you can defer that analysis until you've picked the one spot that is going to be included. And also, occasionally UGB expansions get challenged for other things not related to transportation. And so again, if there are those other challenges to be worked out, go ahead and work all of that out first before you invest in doing the transportation analysis when you know that the UGB expansion is acknowledged. So that's why you don't have to do 060 at the time of a UGB expansion. Well, there was a concern that this could be a real problem if you, at that point, said, I'm going to defer it, but then when you go around to zone it and say, well, we don't have to do the TPR analysis now because it's consistent with our comp plan. So that's why subsection C is in there. Moving on, the other new section that I think is definitely a substantive policy shift. This is a change and going to be very important. Section 10, the multimodal mixed-use areas. We had this concern. I don't know that anybody told the Joint Secretary, but we had a concern that we might be running out of TLAs, three-letter acronyms. We thought the planning profession just might not have enough of those. So it's our duty to step up to the plate and provide another three-letter acronym, the Multimodal Mixed-Use Area, MMA. Basic concept, within this area, exempt from the congestion standards. These are the kind of downtown areas where you expect congestion, where in fact congestion is an indication that it is developing the way you want it. It's intense, it's the downtown, it's the vital, it's the heart. So a local government, city or county, could designate an MMA. Having designated it, rezone land in there without having to look at congestion standards. The important points we'll look at are the definition of what an MMA, what do you do to qualify, and then some special provisions related to interchanges. Oops, this is another good time. If you have your copy of the rule handy, flip back to section 8, which is an existing section. To create the definition for these MMAs, we just reused that. It's on page 5. To say, how do you know if it's an MMA? Well, it needs to allow the range of uses that you will see listed there in capital A through C. Concentration, variety of land uses, residential development, offices, retail, restaurants, civic and cultural, core commercial area, or multi-story buildings. The key item here is that the zoning and development regulations must allow all of these. Doesn't necessarily mean that all of these exist in the area today. And in fact, private development being running by a private decision-making process, we can't guarantee that they will all be there at any particular point in the future, but the zoning needs to at least allow all of those things. If you continue on down that same list, you'll see some development standards that are appropriate to downtown areas or mixed-use areas. Buildings and entrances oriented to the streets, street connections that are safe and convenient, a network of streets that is pedestrian-oriented, transit stops in places where there's transit, and limiting some of the low-intensity uses such as industrial, automobile, sales and service, and drive-throughs. So the development regulations in the city or county need to enforce those. The first part is the allowable. You have to allow those things. This is the must require these things. And again, maybe not every building in the area has these at the time you designate the MMA, but any new development that comes after that had better be adhering to these principles if this is going to be an MMA. Then one final element to the definition is it has to have reduced parking requirements in this area. Doesn't mean that there may still be some parking there now. Private developers may choose to provide parking, but the local government cannot be in the position of saying, you must provide parking in this MMA. If it really is a multimodal mixed-use area, then people are going to be getting there by other means and don't need to be requiring the parking. I mentioned that interchanges are a special issue. And so if you're looking at the rule on the bottom of page 6, under the capital E, talks about some options related to interchanges. Interchanges are a particularly expensive and particularly important part of the state system, and in a few cases part of a county system, but mostly on the state system. They are an area where some additional attention needs to be paid to the potential effects there. Not coincidentally, interchanges are often located near the centers of towns because they provide that important high-level access to those areas. So if the MMA that you're designating is at least a quarter mile away from an interchange, great. No further worries. You can go on and designate the MMA. That's a purely local decision. If it is if the MMA is near an IAMP, and the planning has already been done where the local government and the state government have come to an agreement on what that interchange is, how it's going to work, and this MMA designation consistent, that's great, no problem. If you get to this third option, though, you need to work with ODOT, or if it were a county interchange with the county, and get a concurrence on the designation of the MMA to say this is a genuine MMA, and it is not going to create certain problems on the interchange, or that there will be a way to address those. So if you end up in that third option, the details of how to go about that is addressed in subsection C, and you'll find that on page 7. Talks about when the provider reviews an MMA designation. The key problem to be looking for here, talking about, trying to address, is whether there could be a backup from the exit ramps onto the main line. And the discussion went through at the Rules Advisory Committee, and the different possibilities said, well, if it gets congested and you can't get from one side of the freeway to the other side, that's mostly a local issue. That's local congestion. Folks can't get back and forth within their own city. That's something that it's okay to let be a local decision about an MMA. But when you have stopped vehicles who can't get off the freeway and they're right next to vehicles traveling 60 miles an hour, that's a serious safety problem, and that's something that does need to be addressed in these. The way to address it primarily is going to be through an agreement in subsection CB there that talks about, well, what would we do if this becomes a problem? It's not something where you say, at the time of designating MMA, we know for certain that it will be a problem. If the MMA functions as we hope, in fact, there will be folks coming in lots of modes, and there will be lots of trips captured in there, and it may not generate a lot of travel in and out on the freeway. But it'll be an intense location, and there will still be lots of people getting there. So we want to be prepared for that. It's not to say no, it's to say, if there become these problems, what will we do? An example might be, if we start to have problems with traffic backing up, we'll adjust the signal timing. That'll be the first thing we do to help clear that interchange. Okay, if that doesn't solve it, The agreement could state the next thing to do would be close some of the accesses that are too close to the interchange, some of the driveways that are causing problems. If that doesn't solve it, maybe the next thing to do is to lengthen the ramp. I don't think in very many cases is it going to be, well, let's rebuild the interchange. That's just an incredibly expensive thing. But I guess if a local government had that kind of money, ODOT might accept it. The point is, you've got to work through these with the state and the local government to try to figure out how a series of contingent statements. If these problems develop, here's what we will do to try to manage them. I do want to note that once an MMA is designated, even if it's near an interchange, it operates just the same in terms of rezonings. From then on out, rezonings can occur in that MMA without having to worry about congestion because it's been addressed through this other agreement or these other methods. All right, so that's MMAs. The third and final of the new segments that we added to the Transportation Planning Rule is Section 11, addressing this economic development issue and the concern that perhaps the TPR and OHP was making it hard to do economic development. The things I want to cover in this are some definitions. Well, what is economic development? What do you get if you qualify for that definition? Partial mitigation, and how is that defined? A requirement for concurrence. I just talked a little bit about how you have to work with ODOT when it's near a freeway. Well, there's a similar situation here if there's a state highway being affected. And a coordination requirement, which is different than concurrence, so we need to keep those two separate. If you're looking at the rule on the bottom of page 8 and or bottom of page 7 and the top of page 8 are some definitions about what is economic development. It creates direct benefit in terms of industrial or traded sector jobs created or retained by limiting uses to industrial or traded sector industries. That is the general definition that we came up with through the Rules Advisory Committee. And there are two definitions there. Of course, industrial and traded sector are further defined. I'm not going to read those. They are taken straight from statutes. So if you're familiar with some of the state statutes on economic development, these will be familiar terms. There is, however, in addition to that general definition that applies statewide, there were concerns coming up through the Rules Advisory Committee that that definition may be too tight, too narrow for some situations, and especially for smaller areas and rural areas. That definition just doesn't work. So a broader definition was added. And this is one area where the Rules Advisory Committee did not get it all worked out. We were actually writing text at the LCDC hearing and writing rules text. So what came out of the hearing was not the same as what went into it, and that's in this area. This definition applies in cities with a population under 10,000, outside of a metropolitan planning organization, outside of the Willamette Valley. The definition, I said it was broader. It's very broad. It includes other employment uses. Basically, anything that has jobs would qualify, at least meets the definition to enter this section and to start looking at through Section 11. Other employment uses. A key one that got a lot of discussion is retail. From a statewide perspective, retail is not generally seen as economic development because it's moving jobs around within the state. It's not bringing new money into the state. From a local government perspective, it does often seem a lot like it's economic development. If you can bring some retail into your community that was previously in another community or would otherwise be in another city. So if a proposed rezoning, and remember that all of TPR 060 is about these rezonings or plan amendments, so you don't necessarily know who's going to end up on that site. You might, but in a lot of cases you don't. If the proposed rezoning qualifies as economic development under either one of those definitions, then it is allowable to do or to have plans for partially mitigating the transportation impacts. Partial was something that we didn't think we could define in the rule. It's something that's going to be different each time it comes up in different situations. And it's going to depend on a balancing test to say, well, how much economic benefit is being created or could be created through the jobs that would come in this area, and how big is the transportation effect? If it's going to have a lot of jobs and they're high-value jobs, and it's going to have a fairly small effect on the transportation system, because in this case maybe partial means mostly. You're going to mostly mitigate it. There's just a small amount. all right, that could meet the balancing test. If it was something that's going to bring not very many jobs, but is going to produce tons of traffic, and the mitigation is in fact minimal mitigation and is not getting very far, it has a huge impact, that would not meet the balancing test. And the important question is, well, if there's a balancing test, who does the balancing? And again, it's whoever's facilities are being affected. If it's a city that is proposing this, and it's a city street, and if it's purely city streets being affected, then it would be entirely up to that city to do that balancing test. But if it affects some county roads, then you would need to have a written concurrence from the county. And if, as is often the case, it affects a state highway, you need written concurrence from ODOT about this balancing test. In writing this, ODOT said, well, that's a good, it's nice to have that balancing test, but we are not an economic development agency. How do we deal with these things? So written into the rules is that there's a consultation or a process with Business Oregon at the state level to help define what are those economic benefits to help do that balancing test. There is also a coordination provision in here, and this is one that created some confusion, so I want to be clear. This is at the very end of the rule. In fact, on page 8, subsection C, says when a local government proposes to use this kind of partial mitigation, need to coordinate with, there's a long list of other folks to coordinate with there. We had to choose these words very carefully to say these other entities do not have a veto power. You do not need to get an approval or a permission from all of these agencies or groups listed here. Need to at least inform them about it and accommodate them as much as possible. And this is a definition that comes out of, that existed before our rules, comes out of statute. So we were trying to reuse that term that has been litigated and dealt with in the past. Not concurrence, but does require a notice. All right, those are the new sections. Now I will hit a couple of existing sections where there have been some substantive changes. This one is way back at the beginning of the rule. Section 1 defines what is a significantly affect. And the changes here are in that second column on the first page, where it says as part of evaluating the projected conditions, the amount of traffic projected to be generated may be reduced if there are enforceable ongoing requirements that would demonstrably limit traffic generation, along with a way of saying TDM type stuff, transportation demand management. Anything that reduces the amount of traffic that is produced qualifies through here, as opposed to where you're adding additional capacity by turn lanes or traffic signals or travel lanes or whatever. We felt that it made sense in these situations. If you're not adding any traffic, how can you, just in the ordinary meaning of the English term, affect, how do you have an effect if it doesn't add any traffic? In the past, TDM has always been an option, but it has been used as a corrective action. So you would say, we had an effect and we fixed it through TDM. This now says you don't even have a significant effect. It sounds like the same thing in the end. I mean, either way, you get to an approval. But it turns out that in certain legal cases, it's very important whether you said you don't have an effect. And it does shortcut a fair amount of other analysis that would have to occur about, well, what is the effect, how much, future projections. So I felt it just made more sense to put it here as a streamlining. Another change, fairly substantive, is a new corrective action. Section 2 is the part of 060 that talks about, well, what do you do if you have a significant effect? And there's a whole long list of potential corrective actions, and we added one other item to that list. It's a little bit awkward how we wrote it because we were trying very hard to be mode neutral about it and try to say modes other than or locations other than. So let me just give an example of how this might play out. There's more than one way, but imagine that a proposed rezoning is coming along and the projections are being done. It says, well, this will cause an intersection on say it's a state highway, to fail to meet the motor vehicle congestion standard because it would add a lot of traffic there. But when everybody looks at this spot and says, you know, this is not a good intersection to try to be improving. It already has dual left turn lanes. It's already got traffic signals. It's already got, what else do we really want to do here? You know, it would make more sense to do the improvements on either side of that, upstream and downstream, other intersections along there. And if we did that, that'd give people options. It would help the system work well, but this area would actually still fail on the performance standard. Well, this section now allows that could be a way to mitigate it. What if everybody looks and says, well, the best thing to do would be to create a parallel route so some folks don't have to use that state highway. Local trips could stay on the local system, and maybe the improvements there would be better. Again, you might not actually meet the performance standard on the highway, but you're providing a network or a system benefit. So use that as the mitigation. In other locations, again, maybe this intersection is really is a very large intersection in terms of motor vehicle capacity. It doesn't make sense to try to make it larger. What's really needed here are some pedestrian crossing. It's not safe. What's really needed here, the bike facilities sort of end at this area, and it would be good to improve them through here. That would provide a system-type benefit. This section would give you the option to work on any of those. Again, written concurrence is going to be required from whoever is in charge of that intersection. And the example I gave was on a state highway, so it would need to be from ODOT. If the intersection that was in question was on a county road, you need to get their concurrence. And it's another balancing test. Do those system-wide benefits to other modes, other locations, or other facilities enough to balance out that significant effect? The final section I want to hit on TPR is Section 3, which is a relief valve that works for situations where there's a failure, but it's not because of this particular amendment. In fact, it's just because it's a busy place and it's projected to be a busy place. And so even before the amendment, this was in before the amendment, and it said at that situation the standard is avoid further degradation by the time of development. Prior to this amendment, there were really three parts to how you could apply for, or how to qualify. It's failing now, it's projected to be failing, and nobody's got a funded plan to fix it. Maybe somebody's got an idea, but nobody's been able to show where it's going to get, how it's going to be funded. We changed that to simply say the last two. It's projected to fail, and nobody has a funded fix, but if it's failing now or not, that's not really relevant. This is a planning rule. It's about looking at that plan horizon. That's the important question. One of the situations, you could get into a weird situation where it's not failing today, and so in talking to the applicant, you say, well, you cannot use Section 3, the no further degradation. We need to go, we're going to use 1 and 2, and it's the standard process. But of course, if you would wait a year or two, maybe it would fail, and then I could let you use Section 3. Well, that seems a little bit strange. If it makes sense to use it, go ahead and use Section 3. So this was a somewhat technical fix, but it makes it a little easier to use Section 3. It can help in some situations. So 3 new sections: comprehensive plan, rezone consistent with comprehensive plan, compact development in the downtowns, and economic development, and then 3 existing sections related to TDM as the definition of significant effect, the other facilities, other locations, other modes, and this Section 3, failing facilities. So that brings us to the point on the agenda where we do talk about the OHP amendments. So let me hand off the microphone. Oh.
Matt, before you do that, there's a question from the web. What is the difference between amendment to the zoning map and the proposed zoning?
Amendment to the zoning map, the proposed zoning.
Apparently in the initial paragraph it says an amendment to the zoning map, and in Part A it says the proposed zoning.
Okay, and this is in Section 9.
Mm-hmm.
The lead-in paragraph of Section 9 talks about when Section 9 is applicable, when the amendment is only amending the zoning map. Remember that the TPR 060 can apply when you're amending your comp plan or you're amending your development code, but neither of those qualify to use in Section 9. So the phrasing in the lead-in there just says, this is when Section 9 can apply, when you're amending your zoning map. In A, where it talks about the proposed zoning, that is the new zone. Maybe it's C1, your downtown commercial, or R3, or whatever it is, whatever the new zoning would be. So I guess it's It's a question of the process of amending it versus what is the actual zone you will end up on.
Okay, hello again, everybody. Wanted to take some time to give an overview of the work that ODOT was doing at the same time as DLCD was doing all this work on the transportation planning rule. We again had a coordinated process going on to update Policy 1F of the Oregon Highway Plan, the highway mobility policy. So I'm going to give an overview of what those changes were. I think we're doing well on time, and I'm probably not going to necessarily even take the time that was allotted to me, because I see a lot of familiar faces in the audience, and I have a feeling there's some of those online. So some of you have heard some of this broad overview before. I think a lot of the advantage of this workshop will be sort of the questions and discussion that comes next. And the other thing is, later on in the agenda, we have the opportunity to hear from one of ODOT's region staff folks at Region 1 who can speak to a lot of this in terms of implementation on the ground, which I think will be really helpful for the group as well. So just a little bit on process again for the Oregon Highway Plan. So again, we were working on the same time frame as DLC was working on for the transportation planning rule amendments. What we did is we had really gotten in a lot of stakeholder input through some prior administrative rule efforts that we had, through some prior OHP work we had done, and then a lot of testimony really from the joint subcommittee process that narrowed down the issues and the efforts that need to be worked on, and really what the overall objectives were we were trying to get to. So we built on that process to get us started on the amendments. We still had a really extensive public review and outreach period where we went around the state, had conversations with all of our area commissions on transportation, MPO groups, certain advocacy groups, and others, and made sure we got their input on these amendments as well. We also took advantage of the Rules Advisory Committee that Matt had put together for the TPR amendments as a group already assembled with the expertise on a lot of these issues. So we were at all of those meetings, either giving them an update on where we're at on the highway plan, taking drafts to them, taking outlines in terms of what the types of things we're going to be changing. So we took advantage of that going on. And the Oregon Highway Plan amendments were ultimately adopted by the OTC in last December, so we were able to meet the legislative deadline that was put on us as well through Senate Bill 795. So the more and more that we've gotten into these changes and started implementing these changes, and the more Matt and I have done outreach on this, I'm getting the perspective of that the TPR changes were a lot of where the really on the ground details were contained. Some of the changes that are going to really help, day to day, help people step through the process. What the Oregon Highway Plan changes did is I look at them more as a policy intent type revisions for our agency. We heard a lot of concerns from a lot of the stakeholders about the inability to balance multiple objectives, whether that be economic development, community objectives, multimodal objectives, even safety in some cases, and wanting to better balance all of those. And so we wanted this policy revisions to be really overarching and be reflective of that intent for how we deal with transportation planning on the state highway system. So that's sort of how I characterize the Oregon Highway Plan amendments. So we took this opportunity to do a significant rewrite to the policy. We essentially started from scratch. You will see some old language still in there and parts that were still good, but we went ahead and began at square one, wanting to really have a baseline to implement these changes and work from. So that was sort of the baseline of where we started. If I could speak for just a couple minutes about what some of the overarching changes are in the Oregon Highway Plan, I think it's helpful to see where we've gone on them. One of the things we tried to do was enhance the background that leads into the policy, where a lot of the policy intent discussion comes into play, the policy itself, the implementing actions that are in the policy 1F, and really broaden it. The original 1999 Highway Plan Policy 1F was very focused on highway mobility, and didn't have a lot of discussion on what the other objectives are that we're all trying to balance. Other parts of the OHP did, other parts of our planning work did, but Policy 1F specifically didn't have as much as it should have. So we enhanced the background, we enhanced the policy, we enhanced the implementing actions to make sure that we were including concepts for multimodal discussions, balancing community objectives, economic development, and others, at the same time as we're looking at transportation and traffic mobility on the state highway system. So we wanted that tone throughout. Another really big background change, and this got a ton of discussion outside the agency, got a ton of discussion inside the agency, and discussion continues. Is one that we're probably going to be working with really for some time. As we began drafting these, I mean, it was suggested that if you really want a fundamental change, we got to get beyond thinking of these as really sort of the end-all be-all standards in a lot of cases. And so we kicked around some ideas for a actual change in the terminology. And you know, it turned out to be more difficult. I guess easier said than done is you know, a way to look at this. But you know, we wanted to give it a try. And the reason we wanted to give this change a go was we had flexibility in the old Oregon Highway Plan. We have much more flexibility now through the changes. And we wanted to convey that. You know, standards had a connotation if it's something you meet or you don't, sort of end of story. Targets, you know, it's a starting point. It's a goal we're trying to get to. But it's not necessarily a failure if you're not able to get there. And so we have that flexibility, in particular when we're working with local communities and areas at the system planning level. So transportation system plans, facility plans, you know, area plans in the community, sort of the legislative part of the planning actions. And so we wanted to convey that for that type of work, that our performance measures are really the start, or some people think of it as part of the discussion for system plans, facility plans, and whatnot. It's not necessarily the required end result that you have to get to. And there's a way through the policies that I'm going to talk about more in a minute, a process to step through if you're not able to meet what the standards or targets were. And this is where some of the challenges comes in, is this next point. That being said, we've got flexibility at the system planning stage, facility planning stage. But you know, we just heard a lot about 0060 and some of the requirements that go along with plan amendment, zone changes, and those types of things. So we still needed to have sort of a firm bar, you know, to be able to analyze the significant effects and the impacts. And so essentially for the purposes of you know, the quasi-judicial, the TPR applications, you know, these are still, you know, treated as standards in that sense. So that part of the implementation didn't change, but the idea of flexibility when working with communities early on at a broad look, at a broad level. We hope this terminology change gets at that, but we understand it's going to be, you know, something we're going to have to give a try on and work on as we continue to move forward. So aside from those pretty, you know, broad general policy changes, there were some technical aspects of the Oregon Highway Plan revisions. And a lot of these are specific items that, if you had a chance to look at the slide that Matt had earlier, they came right out of the Joint Subcommittee report. They came right out of the legislation that said, we want you to take a look at these specific items and see how we can you know, make some hay and improvements on those. So one of the things that was listed by the Joint Subcommittee, directly in response to a lot of the stakeholder concerns we were hearing, is in a lot of situations where, you know, the facility was already operating over standard, perhaps a plan amendment was really only adding a few trips, but the way that the policies were set up, the way the rule was set up, they were essentially put in a box of having to do some type of very significant improvement that was perhaps taking in consideration a lot of traffic that wasn't necessarily as a result of the plan amendment, and it was just difficult to mitigate in a lot of those circumstances. So we were asked to look at ways that we can sort of reduce the burden for plan amendments that had only a small increase in traffic. So the way we're able to do that is we established some thresholds in the policies themselves, where if a plan amendment, for the purposes of TPR, added fewer than whatever the established threshold would be for that circumstance, then we're able to say that's a small increase in traffic. It doesn't further degrade our system that may be operating in a congested state anyway. And so that was one of the ways that we can really reduce the burdens for sort of the smaller plan amendments, smaller developments. The bullet here about consistency with the access management TIA thresholds. Well, it just happened to be at this time, and we're continuing to do so. ODOT is working on some really significant changes to the access management permitting program, both at the policy level and the actual administrative rule that implements the access management permits. One of the things that work area had done was establish thresholds for when a transportation impact analysis would even be required in the access permitting world. And so what we did is try to help with consistency both internally and then making it easier for folks that are using all of this. We went ahead and adopted those thresholds as what would make sense for what we would consider a small increase in traffic for plan amendments would be similar to what we can be considering a small increase in traffic for access management when a TIA wouldn't necessarily even be required in that for access management purposes. The way the thresholds are set up is they vary by a type of facility in terms of lanes, traffic volumes and whatnot. But that's an important change that was based right out of the legislation. There's also some revisions that try to get at a little, adding some flexibility for calculating our VC ratios for mitigation. And VC ratio, volume to capacity ratio, is the way that our performance targets are established in the highway plan. There was some frustration, especially even a lot internally from staff, that we work with a developer or someone who's proposing a plan amendment, and we work on what's proportional for their mitigation, what's reasonable for their area, and we get to say a VC ratio of a 0.87. And we look in the OHP and the target is a 0.85. And what it would take to get all the way to the target is something that's really not proportional to their impact. It would be a significant new improvement, maybe an interchange type improvement, an additional lane for miles. And we could really use some flexibility to say, no, you've done all you can do, and you've come close enough to meeting our targets for these purposes. So we were able to add some flexibility in the policy that said that if you're in that situation where you've negotiated what's reasonable proportional mitigation, and you're within a 0.03 VC ratio, we have some flexibility to saying that you've mitigated your impact. So again, a technical change, but one I think can help in a lot of situations. Another one that was given to us from the Joint Subcommittee on Legislation was the idea of full development assumptions. And there was a little bit of some limits on what we could do in the Oregon Highway Plan on this matter. But we did have an action that talked about when you're doing TPR analysis, it used to say be sure you're considering full build-out assumptions, traffic assumptions. We had changed that in the revised policies to be sure that you're considering plan development. And what we mean by that difference is we want the traffic assumptions or the land use assumptions to be reasonable starting point for these negotiations and the analysis. And if you look over the planning period for the local jurisdictions, TSP, comp plan, whatever it might be, what's really likely to happen over that 15 or 20 years? What's really likely to happen in terms of building out that area over 15 or 20 years? Let's not say, well, this thing will ultimately build out, but it may be 50 or 100 years. Let's constrain it. We're talking planning horizon here. Let's be reasonable, realistic with that assumptions for the planning horizon. So that's a very small change, but again, one I think for implementation on state highways, I think can help. So let me talk for a minute about alternate mobility targets, used to be called alternate mobility standards. So again, this is the tool that we had both in old policy and now it's been significantly enhanced, where we're able to work with communities at the system planning level, facility plans, on essentially resetting the bar for congestion thresholds that make sense within the context of that area when it's not feasible to meet what's in the Oregon Highway Plan now. And there may be a lot of very valid reasons why it's not feasible to meet those. There may be environmental constraints that don't make it possible to improve facilities to meet what the full standards are. There may be community characteristics or concerns that make that difficult. And one of the aspects that we added in is certainly there may be financial constraints that make it difficult to meet what the full standards are. So all of those are valid reasons where it may make sense to consider these alternate mobility targets. So we've enhanced that in the policy changes. Let me talk about how we've done that. So the old policy talked about you can change essentially the VC number. So if your old VC standard for this facility was a 0.85, you've gone through a TSP process, you've talked about what sort of management, system management things, land use management techniques that you can do in the area, and you're able, it makes sense, it's feasible to manage to a level of congestion of a 0.95. Well, then you could reset your mobility target at that level. So that was sort of the old paradigm for these. What we've added to is made it much easier to consider area or corridor mobility targets. The idea being if you take a broader look over a corridor, perhaps things aren't functioning necessarily at a particular intersection, but there's perhaps improvements you can make down the road, or if you look broadly, the overall corridor continues to function pretty effectively. And by broadening that look, you're able to take more of a system look. And there was interest from stakeholders in doing so. And Central Oregon, for example, is taking this route with some system planning or corridor planning work that they're starting. And so this was important to a lot of our stakeholders. A very big change that was made in the policies is now allowing a measure outside of VC, different than VC. Our old policies constrained it to be a VC or a VC-related measure. This again was an interest for a lot of the stakeholders, so it came out of the legislation, the Joint Subcommittee's report, and asked us to look into this. And so the way we've set up the policies now is just to allow something else where we're able to work with the community on what makes sense in that area, what we've got the data to implement, where we have the methodology to implement something that's not VC-based. We can do that. We would still have VC as a starting point for the conversations, but where we're able to do something else, we now have the policy framework that would allow that. I do understand that this will raise a lot of questions in terms of, well, what types of things are you thinking about? So we've initiated a lot of research in this area. We have a statewide research project that's nearing completion that's taking a look at what some of alternative mobility measures might be that make sense in these areas. Region 1, which I think you'll hear about a little bit later, had a project that looked into this, what makes sense for the Portland region. And so we realize there's going to be sort of a learning curve and a process moving forward where we're going to have to work together on what some of these other options are. But we're trying to get a better handle on that. And then I think we'll learn as we go, and we'll make it easier as we go. A couple minutes on implementing actions. So this wasn't necessarily something that came directly out of the Joint Subcommittee's report, but I think it kept with the overall theme of making the policy more streamlined, easier to work with. The old policies talked about using our VC ratios for different application areas. Access management, it was a consideration in there, operational decisions. And what we wanted to do was add and enhance the policy to make it clear, what role do our mobility targets have in these different application areas. And so you'll see some changes in the policy that do that. For example, access management, again, what we did in the policy there was be consistent with the work that was coming out of Senate Bill 264, which made significant changes to ODOT's access management program. talking about mobility being a perhaps a consideration in access management decisions, but not necessarily at the forefront where safety or other types of performance measures would be. So again, taking that idea and making sure it's clear in policy 1F. Same type of thing for more development review activities or operations, having it be a consideration, but one consideration, again, among many that we're trying to balance with communities in terms of economics, community development, multimodal considerations, safety, and otherwise. A big one for a lot of the stakeholders, and I know of a lot of interest in the Portland metro area, was better enhancing or doing a better job between coordinating mobility expectations between the planning work we do and the design work that we do in the agency, or the design work that we have on state facilities. So that is in a particular action statement in the OHP policy revisions to continue to improve that. We are having discussions now with Federal Highways on some of this, Federal Highway Administration. This works and meshes really well with initiatives in other parts of our agency called practical design, which is, again, having a context-sensitive type design considerations. And so we're trying to enhance that coordination, and that, I think, is a very important change as we move forward. A couple other I want to point out. So we made some revisions to the mobility standard or target tables themselves. So if you look in the Oregon Highway Plan, the way the mobility targets are set up is they're in two different tables with some footnotes. But essentially, the OHP establishes the mobility target with a VC number that varies for different types of facilities in terms of a statewide facility, a regional facility, within a community, outside a community, within an MPO, and otherwise. And then OHP Table 7 is actually an alternate mobility target that is already in place for the Portland metro area, so it's got its own numbers. One of the things that we wanted to do was make sure that we had a reasonable starting point when we even enter into these mobility conversations, whether it be at system plans or through TPR work or other types of implementation. So we recognized a lot had changed since 1999 when the Oregon Highway Plan tables were first developed or last developed. We've got more congestion in lots of parts of the state, especially within communities. The financial situation that all of us are in for transportation is perhaps different now than it was 10 plus years ago. And we know that's going to be challenging moving forward. So we introduced a proposal and took it out for review to increase the actual VC numbers in the mobility tables for areas within urban growth boundaries, and that change was made. We considered earlier changes outside of urban growth boundaries on rural facilities. Had a lot of feedback from some rural stakeholders that the concern over some of the safety implications of that and other considerations. So we reverted back to what the old target was, the old numbers, but we did change the numbers within urban areas to allow for more congestion before you necessarily even run into TPR issues or make it a more realistic starting point for working with system plans. Raised it 5–10% in a lot of cases, so that was a key change. The last one that I want to mention is the idea of, we realize that some of these changes are significant and they're going to have an effect on our system, good, bad, otherwise, moving forward. And so our commissioners and others were interested in how are we going to tell what the impacts are? How are we going to tell if it's working, not working? Have we hit our mark or not? So we actually added a specific action that we're going to look at the revised policy within 3 years, and then the OTC could elect to continue to look at it on a set schedule afterwards to see how we're doing. Is it helping? Is it not helping? Is it having unintended consequences? A lot of the feedback that we got, especially on the sort of the small increase in traffic, was this is going to have cumulative impacts, and I think that's very true, and it's going to be one of the things that we want to look at in this policy assessment. So we put that actually into the OHP to make sure everyone understood that was important to us as well. So with that, was there any clarifying questions, John, or do we want to move into the break?
I think we'll take the break now.
Okay.
So we're
Yeah.
Okay, we're running nicely ahead of schedule here. No one ever complains about that. So we're going to take a 10-minute break. Folks who are watching online, we've been getting a few questions in. Please continue to send your questions to this email address, psuseminar@yahoo.com. We're getting them here. Matt and Michael will look at the similar ones, combine them, prepare their answers. So we'll come back right now. It's 2:10. We'll come back at 2:20.
Sure.
So we'll come back in 10 minutes as we had planned and start up with answers to your questions. Thank you. See you. Okay, so we're welcoming back our internet audience, and everybody else had their little break. So we have a few questions off the web. How many people in the audience are also itching to ask their question? You tackle everybody during the break? Great. Okay, so I feel like a little bit of a game show up here. I'm going to see if I can ask Matt and yeah, right. Okay, so we have a couple questions off the web that we'll start with. The first one is, what if a text amendment to a zone in an MMA makes the zoning not meet the requirements for designation as an MMA? Is that you? That's for you?
Yeah, sure.
Right, so here's
my card. Okay. So if you've got your copy of the rule, we're talking about the MMAs in Section 10. That's on page 6. If the text amendment, well, the first thing to do is in looking at Section 10, it says, notwithstanding Section 1 and 2 of this rule, local government may amend a functional plan, comprehensive plan, or land use regulation. So this amendment might qualify under Section 10 because it is a change to a land use regulation. But if it says if it makes the zoning not meet the requirements, under subsection A, it talks about a proposed amendment qualifies for this section if, and then paragraph B, capital B, is consistent with the definition of an MMA and consistent with the function of the MMA as described in the findings designating the MMA. So this text amendment would certainly not qualify under Section 10 because it is not consistent with the definition. So it would need to be evaluated under the full process, standard processes related to TPR. If it's allowing some new use, you would need to analyze those potential impacts. And I will say that a local government that did something like this, I hope this is a purely hypothetical question. I hope somebody didn't have a particular plan in mind. At that point, you should repeal the MMA. If the zoning is being changed that it no longer qualifies as an MMA, then it should be repealed. Would be certainly. And if this text amendment is going to allow some new use that would have significant impacts, those impacts would have to be analyzed under the standard process. And I think it would be somewhat tricky because you would have to be analyzing the impacts of this amendment given the potential. Well, if the MMA is repealed, then it's pretty straightforward how you would analyze these impacts. If the local government tried to keep the MMA in place, you'd be trying to analyze the impacts of this amendment given that it's almost unlimited development might occur in the MMA. I don't see how this amendment, if it's allowing more uses, it would be real hard to qualify that because you don't know how much development might happen in the MMA. That's not a problem when you're making amendments consistent with the MMA because you don't have to show that you meet congestion. But this amendment would have to show that it meets congestion standards, and I think that'd be very hard to do.
Okay. Our next question from the web is, what is an example of a zone change that would be inconsistent with the TSP and I think this is a follow-on, is assumed land use as used for the model the indicator, or are there others?
Yes and yes. The assumed land use in a model is a really good place to begin asking, is it consistent with the TSP? Not all TSPs have land use models built within them, especially smaller areas, more rural areas, didn't use a traffic model to try to prepare their TSP simply because congestion was not the big issue in a lot of those places, so no need for a traffic model. But if the TSP was based on a traffic model, that is how I would do it. Pull out the transportation analysis zone map and look on that and figure out, okay, well, which TAZ is this parcel in? And then say, well, what's being proposed for it? Look up, hopefully in the appendix, there's something that shows you what the assumptions were used to produce that. Look at those. Now, an example of one that might be inconsistent, I think the best way to be thinking about that is in the industrial zones, because there's really a wide range. And typical that a comp plan might say this area, the north end of town is our industrial end, and that's where those uses are going to be. You might have an area that's currently zoned heavy industrial, and ironically, heavy industrial usually has the least amount of traffic impact because there aren't that many employees per acre quite often. suppose that the rezoning, if we're trying to create an example of something inconsistent here, was to go to a commercial/industrial zone that some cities use. This zone allows industrial uses, light industrial uses, but also allows retail uses and office uses and things that can be very intense in their traffic impact. So while those both might fit within a comprehensive plan designation, when you do flip through the assumptions in the TSP, you may find that the assumption was here a fairly small number of employees and typically no retail employees. That's another category that's often in those assumptions. So then it would be very hard to argue that a commercial/industrial designation is going to be consistent with those TSP assumptions in that case.
Before we ask more of the questions that are piling up here in the inbox, let me turn to the room and see if anybody has a question. Now, if we do have a few, if you have a microphone on your desk, I can't see if you do. No, I'll let you use this one.
Thank you. Could you brief us, please, on the current status of worst case or best case assumptions for trip generation? It usually comes up in a small tract zoning map amendment that's not in compliance with your comprehensive plan, and usually it's by application, so it's quasi-judicial rather than legislative. And a typical pattern is the zone asks for actually allows quite a bit, and if it was used to its maximum potential would generate a lot of trips. But along with the zone change application, you have an application for a particular development that, you know, on its face doesn't provide for a lot of trips. But the zone change is the zone change, and once the zone change is approved, it allows what's allowed rather than what's proposed for the moment. So what's the current case law and thinking and administrative practices for reviewing a situation like that?
I'm not aware of any changes in case law on that. I think the administrative thinking on that is that we are planning on a planning horizon, on a 15 to 20-year planning horizon. So while knowing that there's a concurrent application for a specific development tells us something about what's happening now, it doesn't tell us a whole lot about what we would be projecting to be happening 20 years out. At that point, as you said, the zoning is the zoning, and all kinds of things could be going on there. Not because the person who we're working with has got any hidden intent or is planning to, and I've heard this suggested sometimes that we're calling the developers a liar when we do this worst case, because they've told us what they're doing, and we take them at their face value. And that's fine for today and for now, but 5 years from now, is that business still going to be there? 10 years from now, is that property owner going to own that property? 20 years from now, well, the zoning is going to be controlling what may happen there, and it may be quite different. So you need to work with that. In some cases, this is where the trip caps are often used. If for some reason they're saying, well, this parcel is really quite suitable for these kinds of uses. No, it wouldn't be suitable for those uses that are more intense than this, but for these, it's fine, let's do it. Either a different zoning that allows those things that seem suitable and doesn't allow the things that are not suitable, or some kind of a trip cap. Be careful with trip caps, because in a lot of places we actually want more development. So I don't like to use trip caps if it's anywhere near a downtown or a potential MMA. Please do not use a trip cap there, because that's actually working in the wrong direction.
Is there a rule of thumb based on the existing case law about what your 20-year generation assumption should be? Would it be 85% of what was theoretically allowed by the law?
I'm not aware of any such rule of thumb. I think it's very much a specific fact-based determination of what is a reasonably most intense case. And
Give an example of maybe a movie case or Court of Appeals case that
no, I'm
case?
not an attorney, and I work with those cases only a little bit. So
I'm going to address this as part of the metro area question.
Okay.
And one thing we have in metro is Metroscope. So if you can figure out from Metroscope what they thought the build-out would be in year 2035, and it's, say, 75%, and you can make the case that your zone change is not going to change what Metroscope predicts because it's based on existing zoning, then you can use that. Or like Tigard had a local specific market study that was the basis for their reasonable worst case. Typically, those only exist for legislative plan amendments, but you can use Metroscope in the metro area, even for quasi-judicial. But you have to make the case that it's reasonable to do so.
The only other thing that I'll add to it is, again, with the OHP changes, the only thing that was really changed on this issue through this process was that revision in the OHP policy. So it's, again, the OHP, so state highways, and how we're going to treat assumptions. And it was the change to making sure we're assuming plan development rather than full development in all cases. And I think that example was really good, where if you can demonstrate what was planned for the area was the 75%. That hasn't changed. There's no reason that we need to be assuming more back up to a full build out or anything like that. So that's the only tweak that was done through this work.
Okay, all right. This is a question for Michael. You said that measures outside VC ratio are now allowed, and I wondered if you could give me some examples of such measures. And on a related note, you said that there's also a statewide research effort underway on alternative mobility standards. What all are they looking at? What's the status, and who's doing it?
Okay.
Thank you.
We had, as this issue first started coming up, we put in some examples into a guidance document that ODOT developed a couple of years ago called the Oregon Highway Plan Mobility Standard Guidelines. That's now due for some revisions based on all these changes, but there were some examples in there. A lot of what we hear folks talk about is wanting to consider some sort of reliability type measure, so perhaps there's some reliability measures in terms of a performance index or a planning time index or something like that that's often mentioned. I think Lidwien is going to talk about the Region 1 specific project, which did get down to a few examples that seem to have some merit and promise for the Portland area. For the statewide research project, we actually had the principal investigator here earlier, but I think he stepped out. So it would be great if he was still here to answer some of that. But as far as the status of that, it's getting very close to the final report. We should have something really any time on that. What they considered was they really did a very thorough literature review of all different kinds of performance measures, mobility measures, and otherwise. And again, we were mainly talking mobility measures in this situation, but knowing other things that could come into play that may supplement it. One of the things that I know that they thought held some promise was, again, looking at things over a network rather than a point-specific VC circumstance. The other ones actually just escape me right now. I'm not sure. I guess we'll see more with the final report. But certainly consider things over a network and things that consider operation over a network. Again, operations, reliability type things are on that list. I think there's interest in making sure that if we're considering other types of measures that we get a good hand on quantifying safety where we can. And so I think safety will come into play. Maybe it's not going to be necessarily a replacement type measure, but again, one that's part of the consideration. Those are the ones that come to mind. Eric, can you think of any others?
A couple others that have come up, especially with some of the smaller jurisdictions east of the mountains. They were mentioning level of service as a tool that they've used before in their communities, so they'd like to have that opportunity. Travel time has come up. A lot of this is going to really come down to the types of data sources and tools and things that we have to be able to calculate that, which is why you really can't specify what a alternate target methodology would be across the state, because every community is going to have a different level of tools. Here in the Portland metro area, with the modeling tools, we have a lot more capabilities than maybe we have in some of the parts of the southern part of the state or eastern part of the state. So that's why we're not getting specific in the policies, but we hope that the research will give us the best clues of which ones make the best sense, at least from a geographical spatial kind of perspective. But we do have several things that we are looking at in that research at this point.
And I think the other one that comes to mind would be an average daily traffic or an annual average traffic assumption or measure. And where that particular comes into play are the facilities, for example, a coastal facility that has a lot of seasonal peaking. So maybe that it makes sense to really look more as an average condition rather than what the extreme, high tourist Saturday is, and do we want to really be planning and building out to that necessarily? So I think a lot of the different measures that get sort of take that approach hold a lot of promise for the communities in different parts of the state.
And just one last thing on the alternate mobility target. One of the pieces we put into the policy was the need to make sure we think systematically and corridor-wise. We don't want to come up with, take US 101 for example. We don't want to be going down from Astoria down to Tillamook or Lincoln City and have 6 different methodologies, community by community by community, that we have to try to keep track of, because we do have to be able to calculate this, replicate it, and work, and not come up with a whole bunch of different methodologies that our staff has to deal with. So trying to do some consistency with that, making sure we're thinking strategically and holistically, and how to make that effective. That'll be a very important part as we develop these alternate different targets if we're going away from V over C. We also have found that V over C, if we try some different things, is still pretty effective and can cover a lot of different areas of the state. Maybe not all, but quite a few.
Okay, let's go back to the inbox. The next question we got on the email is, what if a new zone is being adopted that's not yet referenced in the comp plan? Would the comp plan need amendment first?
I think the answer depends. In most comp plans, and in the way that works smoothest, yes, because the comp plan would clearly indicate which zones fit within each comprehensive plan designation. You'd have a designation and then a list of the zones. And many comprehensive plans are set up that way, and if that's one, it certainly would need to be. Some comprehensive plans are a little bit more implied as far as which zones fit within it. And in that case, it might or might not, depending on just how different this new zone is from the others. I think that's an issue really, though, that exists mostly outside of the specific transportation impacts. I mean, that's going to be true whether you're dealing with 060 or not. So I'm not sure that it comes up different in here.
We have a couple of questions regarding Section 11.
Okay.
So I'll hit you one at a time. The first question about the section is, if a unit of government determines that only their facility is affected, then is the decision, maybe about mitigation or partial mitigation, entirely theirs?
Yes, it is. It always depends on who has authority over the affected facilities. And if all of the facilities that are affected are our city, then it would just be just the city.
Okay. So ready for more Section 11 questions?
Yep.
Okay. For the balancing test under B, is the universe of benefits limited to industrial or traded sector jobs and the negative effects limited to trips added to the transportation network? And then the follow-on question is there case law or other precedent that could help a local government with the balancing test under B?
Well, there wouldn't be any precedents or case law yet on this specific because it's just been adopted. But these definitions have been around. I don't think that it could be as narrow as just industrial or traded sector jobs created because there is that broader definition that's applicable in smaller cities outside Willamette Valley, outside the NPO. So in those cases, economic development would, it's going to be jobs, it's going to be economics, but you couldn't limit it just down to those kinds of jobs to balance out.
Okay. And then on the negative, well, I guess just my initial reaction on it is the negative impacts limited to added trips. I would think not necessarily. I mean, I think safety of the transportation system would come into play really significantly. I mean, I think adding more trips really could be something that everyone could agree is not maybe such a bad thing for the system if safety is not compromised, or if there's a safety benefit from the mitigation that's being put in place, partial or otherwise. That would make that balancing test, I think, much easier. So.
Okay.
The text of the rule says negative effects on the transportation facilities. And it repeats it in two places. One, negative effects on local transportation facilities. And then you have to get concurrence from others if there's a negative effect on their transportation facilities. So that does limit it. The presumption is here, in this rule, we're worried about transportation effects. There may be other negative effects that would be coming in, whether it be wetlands or air pollution that's dealt with elsewhere. But not strictly limited to additional trips. If for some reason this would require interrupting a facility or cutting off some access that used to be granted or used to be, in the past you could walk from this point to this point, now it'll be impossible. In the past, vehicles could switch from this road to that road and we have to cut off that ability. That would be a negative effect on the transportation system, but not strictly related to trips. I'm not sure. I think most of the time it probably would be trips. I can't imagine very many others, but the rule is a little broader than just trips.
Before we continue with the inbox, anything else in the room? Okay, back to the inbox. We have several questions here from somebody. The first one, does being in a regional center automatically make you eligible to be an MMA? What level of analysis would you need to get MMA approval for regional center areas?
Let's hold that question.
Okay. We'll get back to you in just a minute.
Half an hour.
So, all right.
We're going to hit a bunch of
Unless
Portland
we hear
specific.
they have to.
Right. So then the next question, for MMAs, the TPR has a special safety provision to protect ODOT freeway facilities from queuing. Does the queuing provision apply to ramp meters queuing back onto surface streets, or is it only for the off-ramp queuing back onto the freeway?
I think it's only the off-ramp queuing onto the freeway, but let's double check what we actually wrote when we put this rule together.
That would be my reaction to it as well.
Okay, we were on page 7. The first column, there's a Roman numeral 3 down there. It says whether existing or potential future traffic queues on the interchange exit ramps extend onto the mainline highway or the portion of the ramp needed to safely accommodate deceleration. So that's really the key question.
Okay. Yes. And then the final question, I think this is for Michael, is when will ODOT Alternative Mobility Toolbox or standards be ready?
Yeah, that's a good question. I think that's probably the next of our significant guidance documents that needs work based on all these changes and then based on just the growing interest of alternate mobility targets. When would it be ready? My guess is we're going to be starting that within a month or so, when it fall, late summer. I mean, right now it's a 100-page document, but a lot of it was background on really getting up with the idea of alternate mobility targets, and a lot of that still is relevant and good. I think we'll focus a lot more again on enhancing the flexibility and the ability to do these things, but be able to get narrowed in more on the specifics of what the options are for different measures. So I hope it wouldn't take too long, but I mean, it is a large document. It's going to take a few months to get through. I would hope the research projects will be informing that, and they should be ready again any time. So, and that'll be a published research report that will be available as soon as the research is done. So I think that'll be a big focus for us for this year, and hopefully it would be done end of summer, fall sometime.
I think Michael really hit most of the key points. As we develop what those other measures other than V over C are and which ones we think are applicable, that'll take a little bit of time from the research, but it doesn't preclude beginning the conversations with local governments as you're updating TSPs and looking at that and setting what is a reasonable level of performance and expectations for your community, for the state highway system, your local system. We can still begin those conversations, and we may not have all the tools in place. It doesn't preclude us still talking about that. And we, again, to come back to V over C, we do have a lot of flexibility of how we can still define performance with the kind of things we have in the toolbox now, and it may get you, where you need to go. And it's really, if it doesn't, maybe there's a different way to still enhance V over C with something a little bit more too.
Yeah, I think one of the best ways to come up with guidance and best practices is to go through this process with communities that are having these issues and have a planning project upcoming or underway on it. And so we're doing that now. We'll be doing it more in the future. So I think that we'll learn a lot from those as well.
Yeah.
I just have a real quick question about, is this presentation available? Was it in the email, or can it be made available so we can share this with other people in our agencies?
A video recording of this is going to be available as soon as it can be processed and put up, and we will post that, and PSU will have that posted. And then the slides, I will get those posted to our website. We've been editing the slides while the presentation's going on, so we weren't able to publish them beforehand, but we'll have those published on our websites next week.
Yeah, that would be great. Thank you.
Yeah. Okay, any other questions in the room? So, guys, do you want to go? You have next on the agenda at 3:20, in about half an hour, is the statewide wrap-up. Do you want to just go straight into that now?
I think so.
Okay. All right.
I didn't have a whole lot to wrap up. You'll see some addresses there for additional information, the transportation planning rules site, the highway plan for the amendments. Site for the recording this webcast should be available there. One other thing I will mention, many of you probably are on my email list already, how you found out about this. If you're not on my email list already, please do email. The address is, you can get it from there. And I will get you on the list so that you'll know about more of these in the future.
Yeah, I would encourage everybody to take a look at the project websites. There is a lot of material, a lot of background material on those, especially the early information. Talked about a lot of the objectives that we were really trying to get out with these changes, and they're certainly worth taking a look at. The one specific item that I would mention that's on both of our websites actually is a legislative report. Senate Bill 795 also required that we report back to the legislature before February, and so we developed a joint executive summary and then a portion of the report that talked about TPR revisions, a portion that talked about the Oregon Highway Plan revisions, and submitted that to the legislature. Posted it on our website as well. I think that's a nice summary of what was done and why it was done, and may be helpful for background information. So. Yeah, why don't we take a little break, and then we'll get you can think about how long, but
so
a little bit closer to the time.
I'll put myself on the camera here. So for the audience watching online, we are ahead of schedule, so we're improvising here. We'll take just a quick break so we can transfer microphones and shift gears to the Metro focus. So if you joined late and you're trying to catch up, we have been running ahead of schedule. We just finished with our statewide questions and answers. So we'll take just a couple minutes of a break here and then come right back, and Lidwien will give the metro area presentation. So yeah, 5 minutes or less. Okay, thank you very much. Okay, welcome back to our broadcast. Oh, now they're taking pictures of us.
Oh, dear.
Okay, so we're going to move from the statewide focus to metropolitan area focus, and Lidwien Rahman with Region 1 ODOT is going to talk about the Region 1 area. There we
Yes, and I tried to anticipate some of your questions and hopefully hit most of them. So one thing that's different about the Portland metro area is that we already have our own mobility targets. It's in Table 7 of the Oregon Highway Plan. They're not alternative because they've been adopted by the Oregon Transportation Commission, so those are our standards. They are different than the rest of the state. The other thing that's unique about the Portland metro area is that there are many highways, many locations and segments along those highways that will not meet those targets, even those very low 0.99, 1.1 VC targets that we have in the Portland metro area. And that's in the future. Some already don't meet it today, but many don't meet those targets in the future. And the future year in the Portland metro area is 2035, based on the RTP. So what that means is that for plan amendments, the standard is not 0.99 or 1.1. It's no further degradation from the plan performance. So the no further degradation is measured from the future base case, the performance as modeled in the RTP or in your TSP. So it's really important that jurisdictions document what that performance is and what the population and employment assumptions were that went into that. Not just, we talked earlier about Section 9 and zone change in accordance with the comp plan. Well, that's especially useful for those instances. But even for no further degradation, that doesn't, that's not a Section 9 application. It's really helpful to have an appendix or some information that's accessible to traffic consultants who do the traffic impact studies, so they can go from that base case. So there's before and after, meaning with and without the zone change or plan amendment, reasonable worst case analysis required. And no, there are no hard and fast rules for that. It is not a science, it is almost an art. It is different if it's for a very large area compared to one parcel. And the key word here is reasonable. It's not the worst of the worst case. And what's reasonable if you're doing a regional center plan is different than if you're rezoning a single parcel. So the bottom line is, come talk to us about it, reasonable worst case, and also what is the traffic impact analysis methodology that you're going to use. And I can assure you, you'll save yourselves a lot of time as jurisdiction or consultant if you come talk to us before you do all the analysis. So reasonable worst case is not defined in the TPR. There was something in the joint subcommittee recommendations, but we didn't get to that. What the Oregon Highway Plan did clarify is that it is not full build-out. It is the plan development in the plan horizon year, which is your TSP or 20 years, whichever is less. And as I already mentioned earlier, you can use Metroscope, or you can use a local market study as a basis for what is planned development in that year as opposed to build-out. And even under Metroscope, that's not a single number. The number is very different in downtown Portland from downtown Tigard from Damascus. So Metroscope has a geographic element to it, and you can't use somebody else's number for your plan amendment. You cannot use the RTP trips as the basis for your before and after. You can't use it as a basis for your before trip numbers because they're model generated rather than ITE trip generation based, and you can't mix and match those things. So you are comparing reasonable worst case to reasonable worst case with and without the amendment. But what you can do is use the RTP the difference between 2005 and 2035 to come up with assumptions for background growth that are not generated by this particular plan amendment. And we've seen that done quite a bit. Different topic, and it was already alluded to, the relationship between the Metro 2040 centers and the TPR. So first, some basics about the language about Metro centers that is most applicable to plan amendments is the Urban Growth Management Functional Plan Title VI. And they were just amended in the last 2 years. And one section of that says that in order to use the 1.1 and 0.99 VC standards and the 0.99 and 0.99 for corridors and other land uses, you have to actually meet the requirements of that section of Title VI, which says you have to adopt a boundary, and the code has to allow a certain mix and intensity of uses. And it's expressed as persons per acre, so it's not just a residential minimum units per acre, it's persons per acre. It's a big number for the Portland Central City. It's about 60 for town centers. And in order to take advantage of that provision of using the 1.1 and 0.99, they have to readopt the boundary. Even if the town center has been in place for a long time, it has to be readopted, submitted to Metro, and said, for purposes of, taking it to of being eligible, this is my boundary. And it is totally okay if you have a big 2040 town center and you only want to use this provision for a portion of it, which came up during the development of Title VI. You can say, I just want this part of my town center or regional center to take advantage of this provision. And there's hardly any corridors that have adopted boundaries, and there's a lot of confusion. Metro went around and asked jurisdictions, show us the land use action when you adopted the boundary, and it's all over the map. So since Title VI is a new provision, even if you have adopted the boundary in the past, you have to resubmit it, and you can just use, refer to that previous decision, and it'll be easy, but it's still an action that you have to take. Another part of the Urban Growth Boundary Management Functional Plan is this provision that allows, for purposes of plan amendments, taking 30% of trips off the top from the ITE trip generation rate. This part is probably not going to be used as much now that we have the MMA, but as you'll see, there may still be instances where jurisdictions or applicants want to use the 30% and not go the full MMA route. So for the 30% trip generation, the same thing, you have to have a boundary, an adopted boundary, you have to notify ODAT about that decision. You have to the code has to allow a certain mix and intensity of uses, and you have to prohibit new auto-dependent uses such as gas stations, car washes, and auto sales lots. That's the language in Title VI. Plus, you have to have plans to meet the non-single occupant vehicle targets that are RTP performance measures, and they're pretty high for town centers and station communities in the 35 to 40% range. So you have to have a plan for the street system design, street design, transit, bicycle, pedestrian. You have to have a TISMO plan, and you have to have a parking management plan for that particular center corridor, station, community, or main street for which you want to use the 30% trip reduction provision. So it's kind of like you have to do your TSP for that center, because that's what this is the list of things you have to do in a transportation system plan. So it's not, it takes some work for local jurisdictions to do up front legislatively before applicants or developers can apply this 30% trip reduction. So how does that compare to the multimodal mixed-use areas in the, that are now in the TPR? Well, it's not that different, but it's not exactly the same either. The big difference, of course, is that you're totally exempt from the congestion standards. So instead of taking 30% off the trips and then doing the whole analysis and seeing if there's still a significant impact and mitigating, et cetera, you just don't even do any analysis under the MMA. The description of an MMA is pretty similar to, and I have a table that compares them, and we will post that on the websites as well, and I'll go through that. But in neither case is it automatic. So not only is a 2040 center not automatically eligible for 30% or using the mobility targets, a 2040 center is not automatically an MMA. You have to adopt findings, and in the case of the MMA, it's a post-acknowledgement plan amendment. You got to give notice to DLCD. They distribute it to everybody else and to the citizens. Boundary is consistent between the two. You have to adopt a boundary, and that may or may not be coterminous with a 2040 center boundary. I'm sure Metro would prefer if it were, if we didn't have too many different animals out there. But and Metro may also weigh in on that decision of MMA designation, as might DLCD. Has to allow a mix of uses under the MMA, has to allow a density of at least medium to high density residential. So it doesn't say anything in the MMA about the density of employment uses. The MMA says you have to allow multi-story buildings, which is not in Title VI. And for an MMA, the plan and development regulations have to provide for street connections within and from outside into, to the MMA, safe pedestrian crossings, pedestrian-friendly street design, and lower parking requirements than elsewhere. So again, in 2040 centers, you have to have a parking management plan and the ratios consistent with the table in Title VI or in the Regional Transportation Functional Plan. For MMA, it just says it's got to be lower than in the rest of the jurisdiction. Both of these are pretty loosely defined, so it'll be in applying this that we will get to find out, what's good enough. This is the big zinger, actually, about the uses that should be prohibited or limited, and that's, I think the intent is primarily new uses. You may have these existing ones that would continue on as, I forget the terminology, non-conforming uses. But the list is a little longer for MMAs, so you have to limit or prohibit both low-intensity and land-extensive and auto-dependent uses, such as industrial, auto sales and service, drive-thrus, gas stations, car washes, storage facilities, and motels. And this list has been around in the TPR since '91. Hasn't changed. So and then the other thing that's different about the MMA is that if it is within a quarter mile of a highway interchange, you have to do a safety analysis and get consent from ODAT that it is in fact safe to do that. And again, the focus is on queuing on the off-ramps. And if there's already a high crash rate, or if it's a SPIS location, then we would look at that particular interchange a lot more carefully than if there is no such thing. But you're asking ODAT for consent. So even though it doesn't specify, any jurisdiction that wants to designate an MMA would do well to do that analysis to demonstrate to ODAT that it's safe to have an MMA there. So switching gears again, the alternative performance measures research that we did in Region 1. And first of all, the goal was, as with the statewide research, to come up with a menu of potential alternative transportation performance measures. We actually started off with the long list of potential measures from the statewide research, which I was also involved in. So we didn't reinvent the wheel. We didn't, pay for that work twice. And then narrowed it down a little bit for application to the metro area. And we started this before the OHP and TPR amendments were even, I think it was sort of about at the same time, but they were definitely not adopted yet. And as it turns out, the OHP amendments have opened the door for considering these measures. And in the course of that project, it became clear to me that we're probably not really talking about alternative measures, but about additional measures, supplemental measures. And the other thing that became clear is that there's two kinds of measures. One are the measures for TSPs or corridor plans. Is this system, this set of improvements and policies and programs and investments good enough to meet, in the case of the state highways, the OHP mobility targets, which is a different exercise from doing a plan amendment, and is this, the uses allowed under this new zone consistent with the planned function and performance of the transportation system. So, and what works well for a TSP may not work well for a plan amendment, both because of scale, but also because of level of effort. Things that you use a regional model, demand model for, you're not going to do that for a single parcel plan amendment. So we had a lot of conversation about what works well for TSPs versus what works well for plan amendments. And frankly, every TSP I've ever worked on has always had 20 or 30 measures, measures of effectiveness or whatever they're called, to determine if this system as a whole is adequate. There's just many more dimensions to a transportation system than mobility. So we've always looked at safety and other things. We have already, the research project is, I have a final report. It hasn't been published yet. I just got it a week or two ago. We have already, as we were working on it, I've had my list of measures, and Laney and other people at Region 1. So it's already been used in the evaluation measures for the TV Highway Corridor Plan, which will come up with alternative mobility measures, and in the Southwest Corridor Plan. And some of them made it, and some of them didn't, because there's many people that have a role in those processes. It'll be there, and it'll be available for TSPs in the region. And because the RTP was amended, every jurisdiction in the region has to update their TSP. You don't have to come up with alternative mobility measures, but you can, and come talk to us insofar as it applies to the state highways, and they'll probably direct you to me, and I'll tell you what we've got, and I'm going to tell you right now. So what I want to emphasize, though, is ODOT is not going to adopt any of these measures. It's a toolbox, and they're there for people to use in corridor plans or TSPs. And the same thing applies to the alternative performance measures guidelines. It'll just be a toolbox, and they will be adopted for individual corridors or TSPs going through the full OTC, Oregon Highway Plan Amendment process. ODOT's not going to be adopting any alternative measures other than through this locally initiated process. Some next steps. ODOT is working on the least cost planning project, which is now called Mosaic, which looks at performance measures and general and specific indicators, that is what they call them. And those are for to be used in state transportation plans, regional transportation plans, complex corridor plans. So there too, the measures coming out of the research, have made their way. Some of them have made their way into this. So as far as big system planning goes, the least cost planning project is kind of taking that idea and running with it. And when we update the alternative mobility guidelines, we'll probably want to look at that as well. So what are the measures that we considered? For mobility, still look at VC as a base case. Multimodal level of service, and then specifically the bike and ped part of that, because the vehicle part is vehicle LOS, and we decided to go with VC rather than LOS. Look at the non-SOV mode share, and you'll recognize, those of you operating in the Portland metro area, that a lot of these are already metro RTP performance targets, such as the non-SOV mode share. Travel time, VMT, which is becoming a big measure, not just to know how many miles vehicles are running around, but because of their air quality impact, specifically greenhouse gases. And then delay, especially on the freight network. But here are the other measures, the other kinds of measures that don't measure mobility per se. And as part of the research, we didn't just say, you know, what are we going to come up with measures for? We looked at existing ODOT policy documents where we have stated policy that we care about safety, we care about reliability. We just didn't have any standards for them. So for reliability, one of the categories, the recommended measure was the 80th percentile travel time index rather than 95th. A lot of measures for accessibility. And these are mostly GIS-based rather than model-based. So percent of population within X minutes, usually minutes is better than miles because of, you know, the lay of the land and whether it goes up or down or straight. Versus as the crow flies. So accessibility to key destinations, which we have defined in the RTP what those are for this region, to transit stops, to bicycle facilities. And then accessibility is a measure that lends itself well to looking at it with an equity lens. You know, are certain segments of the population, do they have greater accessibility to transit or lesser accessibility to transit or to the bicycle network? So that, and we looked at all these measures with an equity lens as well. Some of them are, you know, work better than others. Safety, what our consultants recommended is to look at a critical rate and also look at a disproportionate rate of certain crash types. So you have averages for your region or for that highway, and are there certain types that are, you know, disproportionately higher in this particular sub-area? I'm going to skip over infrastructure for a second and go to energy and environment, and the recommended measure was tons of pollutants. And then the last one is infrastructure, and that has to do with system completeness. In the RTP, a big new policy concept was this notion of system completeness. And it relates to both street design and street system design. So this is where the street connectivity comes into play, and that would be measured, could be measured by intersection density. Also the idea of having an arterial every mile, you know, and there's of course reasons why you can't always have that. But rather than making a few arterials wider and wider, having more four-lane arterials at a certain spacing, like in East Portland, where it's a pretty regular pattern that way. But also, on every given arterial, there's supposed to be sidewalks, bike lanes, and a certain level of regional transit. So if you have all those, you have a complete system. So when you're looking at a measure, you know, to evaluate your TRSP or even your plan amendment, what % of the plan system is in fact complete is a measure we're looking at. So that's that. And then we looked at a subset of the measures I just talked about that we might be able to work into a system for evaluating plan amendments. And this is the list. So they're not different measures, but it's a subset. What we don't have really is how do you evaluate plan amendments if you have 5 or 6 measures of effectiveness, and how does that work? We're looking at comparing it to the LEAD-ND or to the STARS method of evaluation, where you need, you get points for having better accessibility or more complete system. And what we haven't quite figured out yet, how do you tie that to the significant impact? How many points do you have to rack up to make up for the significant vehicle impact that you're having? Again, the TPR and OHP amendments open the door by saying you can mitigate with improvements to other modes. You can mitigate with improvements to the system, maybe not right at this intersection that doesn't meet the VC, but somewhere else. How do you do that? So these measures are beginning to look at ways that we can actually quantify what's good enough when you're doing those balancing acts. But we haven't quite figured it out in a way that would be fair and equitable and consistent across the state. So we welcome all suggestions in that regard. And that's it. Any questions or discussion?
Simple question on background. What I thought I heard was if there's a particular TPR type of amendment, then you look to the ITE manual to get some guideline on what the trip generation would be for that change. But along with that, you have to consider that effect on the horizon year of your plan. And for that purpose, you could use some kind of city or regional model to get parse out what effect this particular development would have on the eventual horizon, or?
No, you do both before and after for the horizon.
Okay.
And so you don't look at the actual trips in your model. You look at the land uses and how many trips they could generate in the future. Not your current land uses, but the permitted uses under the current zoning, and you compare them to the permitted uses under your proposed zoning. And you use ITE trip generation rates to go from the land use to the trips. So it's really the part about what land uses do you assume that's the most complicated.
So you lead with the land uses before and after land uses. It's land use planning,
it's not traffic engineering.
Right, okay. Well, that's good news.
Yeah.
And so you lead with your land uses and you calculate the trips from the before and after land uses.
So yeah, the reasonable worst case is what's a reasonable set of land uses, and then what trips do they generate.
Right, and you know what the land uses are now, but you have to make some kind of informed estimate of what the horizon year.
And it gets tricky because you have to make assumptions about how much land is going to redevelop, how much is vacant, what's the FAR, how many stories, how many, what's your lot coverage, what are the parking requirements. So what is a reasonable worst case? And generally, there's a lot of steps in documenting that case. So, and like I said, that's the job of land use planners.
And I guess the other big point about the background is what's your base year and what's your horizon year? But as I understand it, your base year was the last time you did a major update to your TSP and reset the horizon. So I think Portland did that in 2002, so our horizon...
Well, you're not really looking at the base year. You're looking at the future forecast, which...
Now, if we
right
did
now, it's whatever your TSP future year is.
Okay, so our horizon year for a 20-year plan in 2002 would be year 2020.
I don't know offhand what the TSP is, but let's say 2020.
For sake of argument, I may be wrong, but if it was 2022, it seems like the consequence of doing your TPR analysis is if you're not refreshing your plan, the closer you get to your horizon year, the shorter your analysis is. So,
it's your horizon or 15 years, whichever is less.
Oh,
so if you haven't updated your TSP lately, we thought of that.
Okay, so it's your horizon. So it's never less than a 15-year look forward. So it's practically it could be 15 to 20 years if you do 20-year plans or something like that. Okay.
Yeah.
Thank you.
That's what I was going to add. The 15-year. minimum
And that's
is
not
in the highway plan.
you know, Metro unique answer. That's
Right,
just the answer.
Yes, that's part of the OHP policies for the minimum of 15-year or the plan.
Okay. Thanks.
Okay, any other questions in the room?
Could you maybe elaborate a little bit more on what kind of analysis ODOT might be thinking about wanting to see when a city wants to establish an MMA around an intersection, in terms of a lot of the MMA requirements are kind of similar to what you and Al were just talking about, are kind of a land use requirement in terms of uses and whatnot. And the analysis that's related to interchanges seems to be more of a technical engineering analysis. So I'm curious what kind of standards ODOT would be thinking about applying when a city is going to be establishing a MMA around an intersection. Are these going to be access management, design, engineering type standards? Are they going to be more, are they going to acknowledge that an MMA has other goals other than moving traffic away from an intersection, such as getting pedestrians?
The TPR amendment itself is very specific that ODOT's consent shall be based on consideration of safety. And we're supposed to look at the current SPIS rates, which is a safety measure. It's a, you know, there's top 10% SPIS rates and top 5% SPIS rates, and those are bad. There's lots of crashes there. Current actual crash rates. So SPIS rates takes raw crash rates and applies a formula, and I don't do this, so I don't know exactly how it works, but you actually get more points for fatalities than for injuries than for property damage only. So it's a weighted rate of crashes, depending on the severity. Did I get that right? And then the likelihood of having backups on the off-ramps, which is it's related to volume, how many people want to get off there, and how long is the storage of the off-ramp. And our objective is to get the people that are getting off to not have people at that low speed of an off-ramp on the main line. So it's the speed differential that you're worried about. And an off-ramp, in part, has the function of decelerating from freeway speed to the stop at the end of the ramp. So it has to be long enough to be able to do that, so you're not slowing down on the main line. So that's an engineering measure.
Yeah. Yeah, again, not much to add there. It's in the TPR. We wanted to, we understood concerns about having it be too wide open, so we wanted to try to put some sort of bookends on it, that it's mainly a safety type analysis. It's mainly safety and operations that impact safety and considerations for the interchange areas. And so those are shown in the TPR. And I think Matt talked about this a fair amount, but a lot of what we see to sort of mitigate that is some sort of management plan that said, if in the future we do have, backups that are moving down the off-ramp or, onto the main line, have a management plan in place to say, well, here's some things we're going to try signal timing-wise or whatever it might be to mitigate that, whether it be now or maybe it comes up in the future. But I think I think we tried to get the framework in the rule so it's pretty clear. Eric, if you have anything on that.
No, I really don't have a whole lot more to add. I think you nailed it. It really is a look at that engineering safety component of making sure that we're not having a 55 or higher to 0 crash situation. And that it forces, if we have that kind of situation, how do we come up with some strategies with our local partners to develop plans and mitigation potentials to help at least minimize, if we can't even eliminate, at least minimize through triggers of next steps. What do we want to do and how do we make this work? So we can still keep those MMA goals and objectives, but still not make our highest order facilities have severe safety issues. Because again, these facilities are the ones that move the vast majority of traffic as well as freight. And if we hinder the safety of those facilities, it does affect the overall economy, not just of the region, but of the state as a whole.
And safety is a multimodal thing. So we had one instance, for instance, where a proposed mitigation would have been 2 left turn lanes, which made it impossible to get the pedestrians across that ramp, and that wouldn't be a good thing. So I don't know what the specific engineering solution was in that case, but we would look at impacts on other modes too.
Okay, we have an empty inbox, so all you folks watching at home can send in your emails about what they can.
Well, no one else is asking questions. It appears that if you're a local planner in the metro region, you've experienced the same thing again, like similar but different requirements from the state of metro. It seems like an MMA is almost the same as Metro Title VI designation, at least for the purposes of analyzing traffic impacts and what the standards are. But my impression is, listening to both, is you kind of get more for less work with an MMA, unless you're within a quarter mile of a freeway interchange. So maybe the ideal situation would be to have an MAA, except for a quarter mile of your freeway interchange, and then do the Metro Title VI 30% reduction for what otherwise should have been in your MMA. That seems to be the course of least resistance. Am I missing something here?
I hope as a land use planner you would consider whether a center on top of a freeway interchange is a good idea in the first place.
Like the central city?
Well, yeah.
I mean, it's already, both features are already there.
Yeah. I think it's going to play in, like, new station communities.
Mm-hmm.
I mean, the centers, the 2040 centers, are where they are.
As are the interchanges.
Yeah, exactly. And we're not likely to have a lot more interchanges. We may have some more centers.
I guess a more serious way to answer that question, I asked the question, I mean, is there any impetus that now the rule has been revised to make the Title VI and the MMA requirements more the same? So if you've done one, you've pretty much done the other, because otherwise we're dealing with very similar but still different requirements. We're doing it one way doesn't necessarily meet the legal standard for the other jurisdiction.
There's definitely conversations between Metro, ODOT, DLCD on that topic, and nobody's actually amending Title VI just yet, but that may very well happen. We're certainly, as staff, we're anticipating that one set of findings would suffice for both, if in fact the requirements are met. But the procedures are a little different, and the Metro process is not that well defined. The whole issue of notice and tracking and things like that.
Okay. Well, thank you.
If I could comment on the connection between those, from the point of view as we were writing the rules, we went back and forth several times about whether we should simply write in the rule that every Metro 2040 center is automatically an MMA and gets qualified for that. And there were a couple of reasons we didn't end up going there. One is not all of the 2040 centers have had local planning to the same level to whether they actually, their aspirations in some cases, and in some cases they're very well planned and documented and implemented aspirations. In other cases there may be more of just an aspiration, haven't gotten there yet. The other was simply there is a dynamic in this state between there's Portland and there's everybody else, and there was a lot of concern that if we wrote a rule that said, oh yeah, folks in the Portland area just get automatic, get right through, and the rest of you go ahead and fill out your forms and send in your files to DLCD and we will review them, that wasn't going to look good. So we ended up with a process where we did not write anybody in automatically. However, I believe that most of the 2040 centers, many of them, ought to be able to get an MMA designation with a page or two of findings. You've already got most of the stuff in place. Now, the big kicker there is that issue with the interchanges. But as far as findings and showing you meet the definitions, I think most of them probably do, and you could get there with some findings. And if you have to make a few code amendments, I hope they're pretty minimal. And I would love to have some pilot projects You were raising your hand to be a pilot project, Judith. Probably good. Because I think it would be very helpful for us at the state to be able to show an example of a successful MMA and be able to hand it to me. Here's an ordinance. Change the name of the city, change the detail. But if it gave folks the basic structure for their findings and their ordinance to do it, that would be very helpful to us. So we're interested.
One more thing on that. I think some of the other discussion around that issue was the MMA of exempting all congestion standards and analysis. What was a significant change from what the 30% or other reduction is, and a lot of the group felt like a proactive public discussion should happen around that. So that was another sort of key consideration.
I thought of one other thing I was going to say. You suggested, perhaps half tongue-in-cheek, that you designate an MMA right up to that quarter-mile mark and then leave the rest out or come at another. I wouldn't want to do that. If legitimately the downtown really does go right up to the interchange and includes that area, I think ultimately you need to do that. Would it make sense perhaps to do it in a phased way? It might, where you designate to begin and say, okay, this area is designated, and now we've got some discussions to go on about that interchange. Maybe it's an interchange area management plan. I'm not saying that's appropriate in all cases, but that might be a vehicle to have that discussion there and work through those issues near the interchange. All right, next question.
So I was on the Rulemaking Advisory Committee, and it was a really it was a great process. It was really interesting, great people at the table. So I've been thinking about it a lot over this past forever. And now that we're here, and I came here for this overview, refresher, see how you guys had organized it so I could do the same. Now I'm at the point where I'm wondering if I'll regret getting what I asked for. Because I'm thinking, and so I'll just ask you, I mean, we haven't done these yet, right? We're still waiting to see what does it look like when we actually start designating MMAs and start identifying alternative mitigation modes and locations and all these things. I mean, I love that we have this flexibility, but remembering that in the community that I work, congestion is a really huge issue. I feel like we need to be really mindful that as we ask for more flexibility, we may get less assurance, that congestion is going to be the same level of priority for the state. Mm-hmm. And that's probably what we need to really be mindful of, that that's part of the deal.
I love you, Judith.
Yeah, I mean, just in responding, yeah, I agree. I mean, a lot of this flexibility is resetting the bar and resetting expectations, and the reason we like the alternate standard or target process is because we do that jointly, and it's public discussion on it. But yeah, there's certainly trade-offs. There's certainly trade-offs to doing so. I think the way a lot of it's set up, it's always, or most often, a local option to go one of these routes or to pursue an alternate standard or to use a part of the TPR. And if that doesn't make sense in the context, it doesn't have to be done. There's the existing targets, there's the existing other parts of the rule that sort of hold things more status quo if that's what makes sense in the area. So there still is that option.
That reminded me of something that was a topic we talked about quite a bit but has kind of fallen off the radar, and this is a bit of a disclaimer coming from the state to local governments that says, if you use these flexibility, they're there for you to do, it's a local decision, understand that the state's financial abilities to come along and address the congestion, I think that's the point you were getting at, is that once you use this flexibility, you're making a long-term decision to live with congestion because there isn't anybody riding to the rescue with bags of money to fix these when it goes on. And we tried several different ways of how to put this, but we ended up with something in the rules. It's on the top of page 2, in section 2. It's in section 2 on page 2. And it says, a local government using some of this flexibility recognizes that additional motor vehicle traffic congestion may result and that other facility providers, i.e. ODOT, or the county, or the transit, would not be expected to provide additional capacity for motor vehicles in response to this congestion. You have the flexibility, or you have some additional flexibility. Don't expect that puts you to the top of the list to get state money because, hey, now we're experiencing great congestion.
So I should take you guys off my speed dial and having a congestion issue.
That's right.
Okay, I'll join you up here. Any more questions this afternoon? We have one more. You get to wrap up one in the inbox. Sorry, I'm switching cameras on these guys. Here's your last question then. Who has the final say about whether a traffic study can or cannot apply the 30% trip reduction allowed for pedestrian-friendly districts? Want that one more time?
Whether the traffic analysis is good enough? Is that more or less the question?
Okay, who has the final say whether the traffic study can or can't apply the 30% trip reduction allowed for pedestrian-friendly districts? So,
whether the 30% applies or not.
yeah, there's about 3 levels.
Yeah.
To this.
Well, whether the 30%, whether the jurisdiction is eligible to use the 30% provision, I think is a Metro say, but we've had conversations with Metro that it isn't real clear, like who has applied and who, did Metro actually bless and said, yes, you're eligible, and then where are we tracking that? So that our traffic analysts know that, downtown Tigard qualifies for the 30%. There is no method right now. And we haven't really, because if you look at the Metro compliance report, they just took one to MTAC this week. Under Title VI, it says, well, this is voluntary. And Metro is really focused on another part of Title VI, which has to do with being eligible for investment in HCT, high-capacity transit. So it hasn't been thought out very well. And ODAT has expressed our opinion that when somebody submits, and says we adopted a boundary and this is our code and we allow these uses and this is how we comply with all the transportation things and this is where, you can see that we prohibit these uses or they're not there on the list of permitted uses, et cetera, et cetera. There is provision in Title VI that we should be getting notice from the local jurisdiction, but there's nothing that says that before Metro says, yes, you're good, that we actually get that there's a opportunity to weigh in on the staff report like there is in a local situation. So it's a little messy.
So the question's coming from a municipality. So presumably, if the county in which that municipality is located could apply for a boundary that encompasses that municipality, or Metro could apply in all of the cities and towns within it. Is that? I'm trying to connect the dots here. That's not my question.
I think the municipality, a local planner is trying to say, how do I know whether the 30% applies? And the answer is, right now we have no idea how you would know that.
Stay tuned.
But we do development review. ODAT does, because as we discovered in the joint subcommittee and all the subsequent, it's usually about a state highway. It's not the TPR is not about state highways, but that's usually where the rub is. And we know there is no list at Metro that says these jurisdictions have submitted and they qualify for, A, B, or C. So as far as we're concerned, nobody's eligible. And in reality, there's always been the provision of the TPR that says you can take a 10% reduction in trips. And that's where, Section 8, the one that defines an MMA, has been there, like I said, since '91. That applied to the 10%. And it always said, if you have better local data to say why it should be 30% or 40% or 50%, because you happen to have light rail and you have a TOD and you have mixed use and all this other stuff, and you can point to some local or national data. That opportunity has always been there. So in reality, it is always it's a conversation, and it's not black and white. You know, the person doing the traffic analysis comes and sits down with our traffic people and our land use people, and we talk about what's reasonable worst case, and we talk about what's a reasonable method and what's reasonable assumptions for pass-by and for background and for internal trips, and every one of those little steps in a traffic impact analysis are discussed, and we like to think we're reasonable, but you know, they'll just keep coming back if they think we're not, and until we get to agreement.
If I understand, though, the basic process, the local government, city or county, would apply and say, we believe the Urban Growth Management Functional Plan Title, we have met Urban Growth Management Functional Plan Title VI.
Yes, not the applicant.
On this boundary, and it's the 30% is good, and then there's a sign-off from Metro before that's official. So there's two things that need to happen, a local government and a Metro approval.
Yes. And it's kind of like the MMA. You know, the local jurisdiction legislatively adopts the boundary and the other provisions. And then, after that's been done, which could be done this week for, you know, unknown plan amendments that may come in the future. So,
correct.
So it's a two-step process. They can be concurrent, but they don't need to be.
But logically, you have to have the one before you use it.
Yes.
In a logical sense, even if chronologically they happen at the same hearing the same night.
And because the 30% and the, you know, using the mobility standards involves Metro, it's a little more difficult to do it concurrently compared to the MMA route.
I think I actually know a little bit more of the answer to that question, because part of Metro's Urban Growth Management Functional Plan is Title VIII, which are their compliance review procedures. So if you were doing it strictly by the book, a local government within Metro's jurisdiction would draw a Title VI boundary as either an amendment to its plan or its land use regulation. It would send the 45-day, now 35-day notification to DLCD. Title VIII of Metro's code requires that that same notice be applied to Metro. If Metro does not object during that period, then when that is acknowledged within the meaning of state law, it is also deemed to comply with the Urban Growth Boundary Functional Plan. So then the question becomes, how does anybody know if Metro did nothing that was okay with Title VI? And then that's the second part that you were talking about, is once a year, Metro is supposed to do a compliance report where it reviews all the jurisdictions within the Metro area and says whether or not they're up to snuff with the various title provisions. The problem has been that Metro has suspended that annual review for years and years and years, and it sounds like they're just doing another one. But so if they do both parts, then there will be an annual report that would say Portland or some other jurisdiction has adequately drawn its Title VI boundaries, and then that would be enough information for Metro's Data Services Center to actually maintain a map of some place of boundaries that actually comport with Title VI. But the compliance procedures haven't been used, maybe 4 or 5 years to their full extent, and that's why we're having these kinds of problems of no hard and fast evidence of what local plan changes that comply with state law also happen to comply with Metro's regional functional plan.
And that makes total sense what you're saying. But Metro hasn't made up its mind whether a voluntary provision, something that you only do if you wish to be eligible for regional investment in HCT or using the lower mobility standards or taking the 30%, it's not compliance in the legal sense of you don't have to comply with it. It's voluntary. So they didn't report on it. They put a big footnote in the compliance report and said, this is a voluntary provision. And that's not to say they won't come up with a method for tracking this, but they have not applied the compliance. It's basically a Dick Benner question, and I'm sure he'll figure it out.
Okay, I have 2 more questions that have come in on the email. This is a longer question, so concentrate.
All right.
Given the background of the Special Transportation Area designation, which has some similarities to the MMA designation, with its application seeming to become more and more difficult each year due to objections from ODOT staff, in parentheses, take downtown Beaverton as an example, how can ODOT ensure that MMAs are implemented as envisioned and not blocked by individual objections? I think the short version of the question is, how can ODOT ensure that MMAs are implemented as envisioned and not blocked by individual objections?
Good question.
Do you want to hear the next question?
No, let me handle that one first.
Phone a friend?
Yeah.
I think that is a good question, and we, in the process of coming up with the OHP amendments, we've had a committee internal to ODOT to come up with those amendments. That same committee worked on the Alternative Mobility Standard guidelines, and a lot of us worked on the TSB guidelines and all. And we have suggested, Region 1, that we should continue that committee or supplement it with people who do actual, development review, preferably, as a kind of check-in to make sure that it's not, up to the whim of the individual planner or traffic analyst how to interpret these things. We also we've had a webinar like this internally, and that one, unlike this one, included a strong message from our director that you will implement these changes. Mm-hmm. And so we will, and all of it. We will collaborate with local jurisdictions in the development of alternative mobility standards. We will, implement the TPR. But yeah, you have to hold our feet to the fire.
Yeah, I agree. A lot of the effort that we've done since the policy changes have been in place have been to get the word out through the agency, and that webcast we had was a big focus of that. We're working on guidance documents that are used day to day by our staff about what the best practices and expectations for implementing this, and I certainly support from the director's office that we're serious about it. For the MMA example specifically, what I thought of was that the way that I think the rule's been set up is, ODOT has a role to play in the designation process, but once things are designated, our role is much less and not at all for congestion anyway. And so I hopefully I don't think that would happen as much as that's being implemented. So, anything else? No? Okay.
I don't know if I can really add a whole lot. I mean, you really nailed it. I mean, clear through our organizational structure, clear up to our director, it's been made very, very clear that we need to engage in these conversations and embrace the opportunities to have these dialogues and opportunities to partner with our other agencies about how is the system going to perform, setting reasonable expectations, and getting joint agreement. That's really what this is about. So we step into this with our eyes wide open with our local government partners so we understand what is going to happen and how it's going to happen. I think Judith's point was actually really good about, kind of careful, but it really is setting those performance bars and expectations, and it's clear up through our management structure. And again, ODOT's role in MMAs is really around the interchanges in the major facilities. Away from the interchanges, we don't have any kind of a significant role there. So that's another part of that. And we're definitely very supportive of the concept. That's clear up through our management structure.
Okay, here's a
Part B.
I think, no, that's a separate question, different questioner. For TPR, if you have a very large area, thousands of acres, with multiple land use types that you are rezoning, can you use travel demand model trip rates rather than ITE trip rates? Since ITE trip rates are samples from specific land use types and are often not representative of trip rates for large areas with multiple land use types.
The first part of my answer would be that the word ITE does not appear anywhere in the TPR. So it is not mandated that you use those, certainly. It's to use the best kind of available information. And I would, not knowing the specifics of this case, but tend to agree that if you're talking about thousands of acres that are being designated in different ways, that you're going to need to use a different tool, and you're going to need to be looking at an averaging out over time, because it's not reasonable to say that the entire site will be covered with the most intense use possible. But it's also not reasonable to say that the entire site is going to be covered with the least intense use possible. So I think a model would be a useful tool in a situation like that.
A couple more thoughts on that. It's important that you do both the before and after using a similar method. So if you're going to use the model for the before, then also do that for the after. You can mix and match. And another thought is, if it is an extremely large area like that, and it is a legislative plan amendment, then in the course of that conversation about what is the reasonable worst case, we would defer to local judgment of what's reasonable for a legislative plan amendment, as we have to legally, more than for a quasi-judicial. Because unless it's clearly arbitrary and capricious, the local government is supposed to interpret their own plan and what's reasonable, and so it might very well be reasonable.
Okay, the final one.
I'd follow up two things. I'm glad you reminded about the consistency of using the same assumptions in both, because that is sometimes a clever applicant might try to take their current zoning and find something really outrageous in that and use that to show how it's not in effect. So you want to use consistent levels of assumptions on both. And the other thing, if it's that big a site, this sounds like time to update a transportation system plan. This doesn't sound like something that should be dealt with through the provisions of 060 as a plan amendment. This is really a major reconfiguration for a city or a county, I should think, and let's look at a bigger system-wide approach in that kind of situation.
Okay, finally from the inbox, have any areas applied or are in the process of applying for MMA designation?
None that I'm aware of.
Okay. No. And with one final refresh of the inbox, quick, call it.
All right.
Anybody else in the room? All right.
Thank you.
I can say thank you. You can say thank you. I'd like to thank everyone who came in the room for attending. I'd like to thank Matt and Lidwien and Michael for presenting.
And we'd like to thank OTREC for giving us this opportunity. We know it's very important to get the word out to everybody, and an avenue like this is very useful.
Okay. Thanks, everybody.